Solicitation is enticing, urging, or otherwise asking another to commit a crime with the intent that they commit the crime. No affirmative response from the solicited party is required. Merges with a targeted offense. Solicitation is complete when defendant asks solicitee to commit the felony. If solicitee agrees, it gives rise to conspiracy and the solicitation merges with the conspiracy. The only crime remaining is conspiracy. Does not matter if the solicited party is convicted or if the solicited crime was impossible to commit. Defenses. Very few defenses apply to solicitation. Refusal by the solicitee is not a defense. Impossibility and withdrawal are not defenses. MPC allows renunciation as a defense, but common law does not. Most jurisdictions allow the common law approach. Conspiracy is an agreement between two or more people to commit a crime or unlawful objective. Required elements are 1, an agreement between two or more people, a meeting of the minds, express agreement, not required. Parties do not need to know each other's existence. 2, intent to enter into an agreement. 3, an intent to commit the targeted crime or pursue the unlawful objective. And 4, an overt act in furtherance of the targeted crime, not a requirement at common law. Unilateral versus bilateral. At common law, 2 or more people must have criminal intent, but MPC allows only one party. Under MPC, defendant may be convicted of conspiracy with another party who was an undercover police officer. Unless otherwise instructed, apply common law rule. Termination. Conspiracy ends upon completion of the targeted crime. Defenses. Impossibility is not a defense to conspiracy. Withdrawal is generally not a defense to conspiracy, but may be a defense to liability for co-conspirators' subsequent crimes. Co-conspirator liability. Each co-conspirator or conspirator is liable for the co-conspirator's crimes that are 1, foreseeable, and 2, committed in furtherance of the conspiracy. Withdrawal. Under common law, one cannot withdraw from the conspiracy itself. MPC allows withdrawal if the withdrawing party thwarts the conspiracy by stopping it or notifying police. Subsequent crimes. One can withdraw from co-conspirators' subsequent crimes, including the target offense of the conspiracy. Affirmative act required. Withdrawal is effective when the withdrawing party makes an affirmative act that notifies his co-conspirators he is withdrawing. Must be timely. Withdrawal must give enough time for co-conspirators to abandon plans for the targeted offense. The withdrawing party must attempt to neutralize the effect of any assistance he provided to the original conspiracy. Attempt is an act done with a specific intent to commit a crime that constitutes an overt or substantial step toward committing the crime, but falls short of committing the crime. An incomplete act that would be a crime if completed. Overt act. Defendant must commit an act beyond mere preparation. defendant must take a substantial step toward committing the targeted crime. Under common law standard, attempt requires an act that is dangerously close to success. Intent. Defendant must specifically intend to commit a particular crime. Defenses. Legal impossibility is a defense to attempt. Factually, impossibility is not a defense. Abandonment is not a defense. Under majority rule, liability for attempt arises once defendant commits an overt act concurrently with a specific intent to commit a crime. Defendant is liable for attempt before he can abandon the crime. Legal insanity is a defense to all crimes regardless of the intent requirement. Depending on the jurisdiction, one of 4 tests used to determine whether defendant was mentally ill when he committed the crime that he should be entitled to acquittal. 4 legal insanity tests are: 1, the McNaughton test, where defendant doesn't know right from wrong due to mental disease or defect. At the time of the offense, defendant lacked the ability to know the wrongfulness of his conduct or understand the nature and quality of his act. 2, irresistible impulse. Defendant acted due to an irresistible impulse. Due to mental illness, defendant was unable to control his actions or conform his conduct to the law. MPC is a combination of the McNaughton and irresistible impulse. As a result of defendant's mental illness, defendant lacked the capacity to either appreciate the criminality of his conduct or conform his conduct to the requirements of the law. And 4, we have the Durham test. But for his mental illness, defendant would not have acted. Defendant's conduct was the product of mental illness. Note, MBE questions will include which test applies. Infancy is a defense to criminal liability for minors. Under 7 years old, there's no criminal liability. 7 to 14 years old, rebuttable presumption against criminal liability. Diminished capacity is a defense based on defendant's mental defect. Available if defendant can show that he has some mental defect short of insanity that prevented him from forming the mental state required for the crime. Usually limited to specific intent crimes. Due process and defendant's mental condition during trial. The Due Process Clause forbids defendants from being tried, convicted, or sentenced if, as a result of mental disease or defect, defendant is unable to either A, understand the nature of the proceedings, or B, assist his lawyer in the preparation of his defense. Capital punishment cannot be executed if he is incapable of understanding the nature and purpose of the punishment at the time of execution. Intoxication. Voluntary intoxication is a defense to specific intent crimes. Voluntary intoxication is when the defendant chooses to consume an intoxicant. Alcoholics and addicts are voluntarily intoxicated. Not available if defendant becomes intoxicated in order to commit the crime. So like a liquid courage. Only a defense to specific intent crimes. Involuntary intoxication is a defense to all crimes. Arises when a defendant was given an intoxicant without her knowledge or forced to consume an intoxicant. Requirements: an intoxicant is taken involuntarily if taken A, without knowledge of its nature, B, under direct duress imposed by another person, or C, pursuant to medical advice without notice of its intoxicating effects. May be treated as a mental illness if, because of the intoxication, defendant satisfies the relevant jurisdiction insanity test.